그럼 두 번째 발표로 넘어가겠습니다. 두 번째 발표는 이갈 아르논&코의 엘라이 그린바움 변호사님께서 오픈소스 소프트웨어 라이선스 해석에 대한 이해를 주제로 발표를 해주시겠습니다. 연사님을 여러분의 환영의 박수와 함께 모시겠습니다.
Hi, it's really an honor and a pleasure to be invited to give this presentation at the Public Domain and Open Source Software License Conference in 2000. I've always wanted to come visit Seoul, and this year was no exception, but unfortunately due to COVID restrictions, I'm unable to join you personally. I hope that in the future, I will have the opportunity to come and visit your beautiful city. My name is Ellie Greenbaum. I'm a lawyer located in Jerusalem, Israel. And I'm very much embedded in the high-tech ecosystem here located in Israel. Today I'd like to give a short presentation about open source interpretation. So open source interpretation, or the interpretation of free and open source software licenses, is a topic that's always in the background of discussions and controversies concerning open source licenses. Every discussion about them assumes some assumptions about how those licenses should be interpreted, or what forms of authority or evidence should be taken and brought to bear on the interpretation of those licenses. But we rarely talk about this topic explicitly. It's rarely a topic that's brought into the foreground. And I'd like to take this opportunity to talk for a few moments and give some thoughts about how we can approach this important topic. So, first, I'd like to start off with an example, a short example. And I'll take this example from the text of the General Public License, version 2 of that license. This is not an example that we talk about very frequently, but it's an example that has been the subject of some frequent controversies and discussions in the literature and in journals regarding free and open source software. So I think it's very germane to talk about this example. The example is taken from the text of the General Public License, version 2 of that license. And as many of you know, the General Public License is a free and open source software license that imposes some obligations on the users of that license. So, just to give a very short example, if I am using some software pursuant to the General Public License, and I want to distribute that software to third parties, I can't just give those third parties the executable code of that software. I must also give them, according to the terms of the General Public License, I must also give them the source code of that license. And the General Public License provides a short definition of what we mean when we say that I must provide to third parties the source code of that license. So, in Section 3 of version 2 of the license, General Public License provides that complete source code means all the source code for all the modules, so all of the source code basically, plus any associated interface definition files. That's not the very clearest language that I can imagine, but that's what it says. We'll skip that for a second. Plus the scripts used to control compilation and installation of the executable. And the language that we'll focus on is plus the scripts used to control installation of the executable. So does this language mean, as some commentators have contended, that when I provide source code as required by the terms of the General Public License, that I also have to provide a means to the users, to the recipients of those source codes, to reinstall the source code that I'm providing to them. So for example, if I'm providing to my users a hardware device that includes source code from the General Public License, do I just have to provide them that source code and say, well, thank you, users. You can go find another hardware device and install you can change that code, but you must find another hardware device in order to install any modified version of the software? Or must I actually give them, my users, the opportunity to install any modified version of the source code that they may create on the same hardware device? Do I actually have to allow them to change the software on the hardware device that I've provided? And some have contended that this language, which says scripts used to control installation of the executable, means that I must provide my users with the opportunity to install any modified versions of the software on any hardware that I may provide. In other words, so for example, if the hardware is protected by some cryptographic key, then I must allow my users access to that cryptographic key so that they can reinstall any modified version of the software on that hardware. That's at least the contention of some commentators. And other commentators oppose that language and say, no, that's not what the language means at all. So if we're going to make a decision about what this language means, we have to interpret the license. We have to decide what principles we are going to use to interpret this license and how we are going to decide what this language means. So, interpretation. What are the principles of interpreting a document, a legal document? Usually courts will say, and obviously this changes and depends on the jurisdiction that we're in. And I'm sure that we have one law, that courts in New York or Israel or South Korea all take very different approaches. But generally, in my experience, the approaches of courts have been that the goal of interpretation is to determine the intent of the parties. When we interpret a license, we have to determine what the intent of the parties to this license is. If we have a contract, we have to determine what the intent of the parties to the contract is. There are various ways of deciding what that intent can be, looking at the contract, looking at extrinsic evidence, but fundamentally, the goal of a court or the goal of interpretation is determining the intent of the parties in entering into this document. So, often, courts use various principles in order to decide what the intent of the parties is. So, and here I'm going to give a very brief summary, and obviously this will differ depending on the exact jurisdiction of the parties. And again, courts in New York or Israel or South Korea may have very different approaches. But generally speaking, when interpreting a document, courts will first look at the intrinsic evidence. What does the document itself say? So, first they will look to the written terms. What does the document say? What is written in this document? If that's not clear enough, or at least if one of the parties claim that that document itself is not clear enough, then courts will look to canons of construction. And what that means is the rules of interpretation. There can be very specific rules for interpreting documents. For example, singular can also mean plural, male can also mean female. For example, very simple rules of interpretation, what we mean when there's inclusive language, or what we mean when language is not inclusive. In other words, fundamental rules of interpretation of the document. And finally, after we've looked at the written terms and the canons of construction, then courts will obviously use reasonable common sense in trying to understand what that document means. Aside from the document itself, aside from the written document itself, courts will often look to what we consider extrinsic evidence. And extrinsic evidence means fundamentally, basically, evidence that is outside the document itself. So that could include, and again, this will differ depending on the jurisdiction of the parties, but that could include the course of performance. How do the parties behave under this contract? Because how the parties behave can give some evidence as to what their intentions were. What is the course of dealing of the parties? How did the parties relate to each other? Not just in the context of this contract, but in the context of their relationship in general. And again, the reason is because if we look at the relationship of the parties, it can give us some idea of what they meant, what their intentions were in the context of any specific agreement. And then courts will often look to the usage of trade. What do words mean in the general marketplace, in the trade? Courts will often look to that. And then, if none of that is clear, courts will often look to the negotiations of the parties. So at some point, the parties were negotiating between themselves. They may have discussed the language or disputed the language or gone back and forth and changed the language in the contract itself. And what can these negotiations tell us about the intention of the parties? But fundamentally, all of this, the intrinsic evidence and the extrinsic evidence, the language of the document and the language of the parties, outside of the behavior of the parties outside of the document, fundamentally, very frequently, the purpose of this entire examination is for a court to determine the intent of the parties. For the court to understand what the parties meant when they entered into this contract. Now, the question is, does this goal determine the intention of the parties also apply in the context of free and open source licenses? If a free and open source software license is interpreted in the same manner as any other legal document, then again, the goal of the courts should often be to determine the intent of the parties. And what this would mean in practice is that there is a licensor, there is a copyright holder, there is some party that wrote the software, the material that's being licensed, and there is a party that's using that software, that material. And if we were to use standard processes of interpretation, then we would say that the goal of the court in trying to determine the language in any document, including free and open source software licenses, should be to understand the intentions of the parties, the intentions of the licensor and the licensee in the context of this transaction. So, if a licensor has made it clear that he is licensing any software under specific terms, then obviously the goal of the court should be to understand what those terms are. Now, I just want to be clear that the process that I've outlined so far is how legal scholars often look at free and open source software licenses, in that the goal of interpretation should be to determine the intent of the parties. That is not often how community participants approach the question of interpretation of the licenses. If you will just pull someone off the street, a software developer who's involved in an open source community, and you ask him, how should you interpret the license? Then they will often say, well, we should look to the intentions of the authors of the license, what the authors mean. So, for example, in the context of the general public license, we should look to the intentions of the Free Software Foundation. What did they mean when they were interpreting the license? What were their intentions in writing the license? What have they written on their website about the license, etc., etc. But I don't think that that's how most legal scholars would approach the question. Most of them would say, no, the Free Software Foundation is the author of the license. They've put a template license out into the public, out into the community for people to use. But when we actually need to interpret what that license means, the intentions of the Free Software Foundation as the author of the license are less important than what the participants to the licensing transaction actually meant. And if we need to understand what any license means, we need to understand what the intentions of the parties were, what the intentions of the licensor and the licensee to this transaction are. Now, I want to argue that this is not the way that we should interpret free and open source software licenses. And the reason is because free and open source software licenses are really template agreements. They're not an agreement that's negotiated between two parties. They're a template agreement that are often and frequently reused in multiple kinds of transactions. And there's very few changes to the language in any of these transactions. The two parties to the transaction will simply take the license, make minimal, if any, changes to the wording, and simply put it on the software that they want to license. The parties will not negotiate what the language of the license is. The licensor will simply say, listen, my software is being made available under the terms of the general public license, the Apache license, etc. And the other party will accept that. And there will be no negotiation as to the wording of the license or as to the meaning of the license. It will just be a template agreement that's attached to the software, and the software is made available in the world according to the terms of that software. Now, free and open source software licenses are not the only documents in the world that are like that. There are other documents, for example, ISDA in financial swaps transactions, that are those kind of documents. They're template documents that are used over and over and over again in the marketplace with some but minimal changes. And Incoterms are another example. And there's lots of different examples. trade organizations can often make template documents available for the use by their members, and often those template documents are used as template documents with minimal changes. But I think that free and open source software licenses are very much template agreements. For example, frequently the parties, the licensor, will not even put the name of put the text of the license on the software. They'll simply say, listen, my software is made available under the terms of this license, under the terms of this template license. And the licensee will know where to find the language of that template license. But there will frequently, the parties refer to the licenses as templates rather than specific language. Indeed, there's often a concern of license proliferation in free and source software open communities. So parties want there to be a limited amount of software templates. They don't want there to be too many kind of licenses. This concern evidences a desire to limit the kind of free and source software, open source software licenses to a specific limited number of templates. In other words, the fact that the licenses are templates is important to the community. The community wants to know, wants to be able to assess the licensing terms of any specific piece of software with minimal investment of resources. And to that effect, it's important to the community that that the number of licensed templates be kept to a minimum, and that parties do not invent their own unique, sui generis, free and open source software licenses, but rather that the parties stick with the standard free and source software licenses that we see in the wild. Free and source open source licenses are often used between heterogeneous parties, meaning that the licensor can be a very large multinational, or it could be a single developer. In the same sense, the party on the other side can be a large multinational company or a very small developer. They could be in different parts of the supply chain. They could be licensors. They could be intermediate. They could be aggregators of the software. In other words, open source licenses are used throughout the supply chain in different positions of the supply chain with different parties, and none of these parties change, or very infrequently change, the language of the licenses. Rather, all the parties, all the various different parties, large, small, whatever jurisdiction, wherever they are located in the supply chain, give reference to the specific template, the specific license template that is being used. There is very, very infrequently do the parties actually negotiate. Another principle in open source software licenses, which emphasizes the fact that these are licensed templates, is the principle of non-discrimination. So if you look at what constitutes an open source license, and you look to the open source definition of the Open Source Initiative, or to the free software definition of the Free Software Foundation, you will see that the principle of non-discrimination plays an important role there. The principle of non-discrimination is basically that any user, any potential user of the software can use that software pursuant to the terms without any discrimination as to why that party is using it, if that party, the nationality of that party, the potential use of that party, the location of that party, the gender, the race, the religion of that party. Everyone is allowed to use that software. There is no discrimination between parties regarding the use of open source software. This feeds into the fact that these licenses are templates. If these licenses were negotiated between different parties, or even interpreted differently based upon the position of the parties, or their nationality, or their race, or religion, or gender, then we would no longer have template licenses. We would have licenses that change depending on the position of the parties. So the fact that this principle of non-discrimination is an important principle in open source software licenses, again, emphasizes the fact that these licenses are fundamentally template licenses. So again, how does the fact that these are template licenses affect our goals in interpreting a license, interpreting an open source software license? So if typically we had said that the goal of interpreting an open source software license is to determine the intent of the parties, I'm sorry, I misspoke. if we said that in ordinary legal relationships, in ordinary legal contracts, the intent is to determine the goal of interpretation is to determine the intent of the parties, well, that would be a little strange in the context of open source licenses that are templates. Because if we're talking about a template, then the meaning really shouldn't change depending on the specific parties to the transaction. The meaning should stay similar because that's the point of having a template. And indeed, the principles that we talked about before, especially the principle of non-discrimination, emphasizes that the interpretation of these licenses should stay consistent regardless of who the parties to the transaction are, regardless of the intention of the licensor and the licensee. So it would be a little odd to say that the goal of interpreting open source licenses should be the same goal that we use in ordinary legal relationships to determine the intent of the parties, because that seems a little strange in the context of template licenses. So I would like to offer a proposal. And this proposal is based on a series of court cases, which I refer to below, in New York and in the United States, in which the courts have looked to template licenses. And basically, I'm simplifying a bit, but basically what they have said is that in template licenses, the goal of interpretation should be basically not to understand the position of the parties, the intention of the specific parties, the intention of the specific licensor and licensee to the transaction in order to understand the language of the license. Rather, the goal should be to understand the marketplace. What does the marketplace think of the license? How does the marketplace interpret the license? How does the community interpret and give meaning to the specific words in the license? In other words, when we interpret template licenses, according to this line of cases in the United States, the goal should not be to look at the specific parties to the transaction, to the specific intentions of the licensor and the licensee, but rather to understand how these documents are understood in the community. And once we understand how these documents are understood in the community, then we can go back to this specific transaction, to the licensor and licensee, and we can say, licensor and licensee, we don't really want to look at your specific intentions here, whatever they may be. We're just going to assume that your understanding of this license was basically the way it's understood in the community. And my proposal is to say that we should, when we try and interpret free and open source software licenses, that we should also try and interpret them with this goal in mind. That this is the way. This should be the goal of interpretation for free and open source software licenses. So, going back to the example I gave, I said, if you recall, I gave an example of how we should interpret Section 3 of Version 2 of the General Public License. And the question was, when the license uses the language plus the script to control installation of the executable, does that mean that the user of the software actually has to give his users or her users the ability to reinstall the software on any hardware? Does he actually have to allow those users to control the installation of any modified versions of the executable? That is the question. How do we interpret this section in the General Public License? And that really goes back to a specific, in order to understand the interpretation of that, language, we have to go back, and we'll take a step back and look at some history. So, and while this language was from the General Public License Version 2, we have to understand the history of the drafting of the General Public License Version 3. So we'll take a few moments to understand that history, and then we'll go back to the language in Version 2 and see how it should be understood. So, typoization. This is the historical occurrence that led to the drafting of the relevant provisions in Version 3 of the General Public License. In the 2000s, TiVo, which was a hardware manufacturer, provided in the marketplace DVR devices that had an installed Linux kernel. Linux, as you know, is licensed under Version 2 of the General Public License, and TiVo devices had a cryptographic hash to check against modified versions of the Linux kernel. So, if you had a version of this hardware device and you wanted to reinstall Linux on these hardware devices, TiVo would not work on the modified versions of the kernel. You could theoretically take a modified version of the Linux kernel and reinstall it on the hardware, but that would cause the hardware to stop working. In other words, TiVo would provide you with the source code of the Linux kernel, which was on the device, as required by the general public license. But they did not provide you with the opportunity to reinstall any modified versions of that Linux software and have the hardware continue working. The hardware would cease to work if you modified the Linux kernel in any way. That is what TiVo did. They provided the software, but they did not allow the hardware to continue working if it was reinstalled. And this prompted a certain provision in version 3 of the general public license. And that version of the general public license, previously we had been talking about version 2 of the general public license, and now we're talking about version 3 of the general public license. Version 3 had an express requirement that the user would have to provide any authorization keys to reinstall the software on the hardware. In other words, let's go back for a second. In the previous language, in version 2 of the general public license, it was not completely clear, or perhaps it did not require that the user provide any installation keys to allow reinstallation of the hardware, of the software on the device. In version 3, it was quite explicit that the user had to provide any authorization keys and the graphic hashes in order to allow reinstallation of the device, of the software source code on the device. So the question, as we talked about, is does the version 2 of the GPL require the provision of installation information? Does version 2, the language that we previously looked at, does it, as version 3 of the license, does it also require provision of installation information? And this question has been the subject of quite a few recent articles. So on March 25th, Denver Gingerich, and I hope I'm pronouncing that correctly, wrote an article asserting that version 2 historically did require that. There was a response article by McCoy-Smith, who argued for a number of reasons that version 2 did not require the installation of the installation keys, which would allow reinstallation of the source code on the hardware. And then there was a reply by Bradley Kuhn, who in his blog asserted that no, McCoy-Smith was mistaken, and indeed version 2 of the license did require users to allow to allow reinstallation of the software on the hardware. And all of these individuals brought to bear certain evidence on their specific preferred interpretation of the license. And I'd like to look at some of the evidence that they brought and see how it fits into the various paradigms of interpretation that we've outlined previously in this presentation. So, for example, some of these various themed scholars have looked to the interpretation of the copyright holders, of the writers of the Linux kernel. They've said, well, these writers may have intended that the GPL mean this, and others have said, no, other copyright holders have not made that intention. And as we've said, ordinarily, if we're taking an ordinary approach to the interpretation of free and source software licenses, we would say that the goal of interpretation is indeed to determine the intent of these copyright holders. But as we can see, in the case of free and open source software licenses, it often results in confusion, because free and open source software projects often have a very large number of copyright holders, and it would be impossible for us to take the account of the intentions of each and every one of the copyright holders. And indeed, these intentions may conflict with each other. So it makes no sense for us to say, when we're interpreting these licenses, that we should look to the intentions of the copyright holders. That does not provide a coherent manner for us to come to a clear conclusion as to what this license means. Other arguments that were raised in the context of this series of articles look to the text of the licenses. And obviously, that's something that needs to be taken account of. So in version 2 of the general public license, what does scripts mean? Does scripts mean actually that we need to provide authorization keys? Maybe it does, maybe it doesn't, but that is a coherent, a valid question that we can look to in trying to interpret the license. And we can also look to a comparison of version 2 and version 3 of the licenses. That is intrinsic. This textual comparison can also shed light on the licenses themselves, what the text in one license says versus the text in the other license. So these are textual arguments, and they obviously are valid in the context of discussions regarding interpretation. There are other arguments that these authors bring to bear as well. There are, for example, many of these authors talk about the intent of the original authors of the GPL, the Free Software Foundation of the GPL version 2. What did the Free Software Foundation mean when they wrote version 2 of the license? And to some extent, this is obviously connected to the historical understanding of the TiVo episode that we've summarized previously. And these arguments make reference to the statements of the Free Software Foundation during the drafting of the licenses, the statements of Richard Stallman during the drafting of the licenses, and also, though there's less material available about this, the goals of Richard Stallman in drafting version 2 of the licenses. And the Free Software Foundation and Richard Stallman were, both of them were deeply involved in the drafting of version 2 and version 3 of the licenses, and obviously they are to some extent the authors of these licenses. And therefore, in the discussions regarding how version 2 of the license should be interpreted, the various scholars make references to how the original authors of the GPL should understand the language of the license. However, I think that despite the fact that these scholars make references to the intentions of the original authors of version 2 of the GPL, that this is really not how an exercise in interpretation of the licenses should be directed. As we said, I think that these licenses should be looked at as template agreements, and the intentions of the original authors of these agreements should be less important than how the community generally understands these licenses. So we can't completely discount the original authors of the licenses, but to some extent, I think that when we're looking towards the understanding of the community and the marketplace, that the intentions of the original authors should have less weight. And then, both all three of the authors in the articles that I referred to earlier make references to community understandings of version 2. And here I think that these understandings are really directed to how we should understand the licenses, and these are the most important kind of evidence that we should look to when understanding the licenses. And again, the authors of these articles make references to TiVo's historical action. So TiVo was operating under the General Public License version 2. What did TiVo do? TiVo, who is a licensee in the community, is obviously acting with some sort of community understanding. What did the community want from TiVo? What did TiVo do? TiVo's actual actions in the historical context, provide some evidence of what the community thought, how the version 2 of the license should be interpreted. And again, all three of the scholars in the articles I referenced talk about how community actors understood the requirements of version 2 versus version 3 of the general. And they talk about how certain community actors, for example, in the Linux kernel, refused to adopt version 3 of the the general public license because they believed that it included further obligations than were in general the version 2 of the license. And again, this evidence, to some extent, this evidences the community understanding of how these licenses should be interpreted, which I think is the most important kind of evidence that we should look to in understanding these licenses. Scholars also look to the community drafting process of GPL v3. So when the process of version 3 of the general public license was not drafted by a single individual, but the community brought together a lot of entities and individuals in the community came together to provide a draft of the general public license. And there were discussions and debates as to how that language should be and what should be incorporated in that language, in the language. And again, I think that these debates, this process of drafting, the community drafting process, gives evidence as to how these licenses should be understood. And I think that is very important evidence because, as I said, when we're looking towards template licenses, the evidence of how the community understood the licenses are very important. And again, these authors make references to the frequently asked questions of the Free Software Foundation and how the Free Software Foundation understood the licenses. And again, to some extent, I want to be clear here, that reflects the community understanding. The Free Software Foundation is an author of the license, but it's also a community participant. And it also affects how the community understands the licenses. So the web pages of the Free Software Foundation should also be taken into account as evidence in understanding how this language should be interpreted. So, just to sum up, I gave an example in version 2 of the General Public License of some language that is subject to current controversy. I said, at least in my opinion, that while most legal scholars in interpreting that language would generally try to understand the intentions of the parties to the transaction, I said I do not believe that that is really the most coherent way of understanding and interpreting open source software licenses. Rather, we should look to the understanding of the community in understanding those open source software licenses. Then I gave an example of various scholars that have different opinions about how this language should be interpreted. And I tried to categorize the various kind of evidence that they brought in order to give an understanding and interpretation of this language. And I tried to say that some of that evidence is less important, some of that evidence is more important towards our goal in understanding how the licenses should be interpreted. Obviously, in this short lecture, I'm not going to give my own opinion of what the proper understanding of the licenses is. That's not the goal of this lecture. This goal is just to give some thoughts about how we should approach the question of interpreting the licenses. Anyways, thank you very much. I hope you enjoyed this presentation. I hope that in the future I will have the opportunity to meet you all here in. Thank you again. Thank you very much.
네, 고맙습니다. 네, 엘라이 그린바움 변호사님의 강연이었습니다. 이번에도 역시 화상 연결을 통해서 질의응답 시간 갖겠습니다. 엘라이 그린바움 변호사님께 올라온 질문 중에서 제가 시간 관계상 한 가지만 골라서 질문을 드려보도록 하겠습니다. 먼저 지금 연결해 볼게요. 엘라이 그린바움 변호사님, 제 목소리 들리시나요?
Can you hear me, Mr. Greenbaum?
I can hear you. Can you hear me?
예, 좋습니다. 그럼 질문 들어가겠습니다. 안녕하세요. 오픈소스 분쟁은 단순히 저작권의 분쟁이 아니라 최근의 분쟁 사례를 보면 저작권과 계약법에 대한 이슈가 추가되어 복잡화되고 있는 것 같습니다. 미래에는 오픈소스 분쟁이 어떤 방향으로 흘러갈까요? 라는 질문입니다.
So here's the question. Due to time constraint, we ask you just one question. I think open source lawsuits have become more complicated as IP rights and Contract Act issues have added. What do you think open source lawsuits will be in the future?
So I agree to some extent that open source licenses have become more complicated as IP rights have become more complex. For example, I think the GPL, version 3 of the GPL is a more complicated legal document than version 2 of the GPL. On the other hand, there is some effort to simplify these documents and to come to open source documents that are much simpler and easier to understand. There is an effort right now, for example, to develop a copyleft next license, which would be much simpler than the GPL, but essentially perform the same, get to the same place as the GPL. And I think that these issues of interpretation will be important to the extent the documents are complex, and perhaps even more so to the extent these documents become simplified, because obviously simplified documents are shorter, and we have to understand the background and the intent of the parties, perhaps, parties to the transactions and the community when we read them. So thank you for that question. It's a good question.
네, thank you. 감사합니다. 여러분들의 심도 깊은 질문 감사드리고요. 또 이어서 이것에 대한 내용을 알려주시겠습니다.
네. 이 질문에 동의합니다. 이 문제들이 특히 오픈소스 분쟁 문제들과 저작권법 관련해서 굉장히 복잡해지고 있습니다. 예를 들어서 GPL 문제도 그렇고 최근에는 윈도우에도 많은 분쟁 문제가 있었습니다. 또 오픈소스 소프트웨어 표준화 문제에도 역시 이러한 분쟁이 있었습니다. 그리고 이런 문제를 해결하기 위한 보이지 않는 노력들이 계속되고 있고 또 GPL에 대한 이 문제들을 좀 더 명확하게 하기 위한 그런 노력들도 역시 함께하고 있습니다. 앞으로 이런 법적 분쟁들은 문서들이 복잡화되면서 더욱더 어려워질 것으로 예상됩니다. 이 때문에 이러한 배경들과 미리 지식들을 이해하고 알고 있는 것이 중요하다고 생각합니다. 감사합니다.
네, 엘라이 그린바움 변호사님의 훌륭한 답변까지 잘 들었습니다. 고맙습니다.
So thank you for your answer and thank you for having your time, Mr. Greenbaum.
Thank you very much. Thank you for having me.